Hello and welcome to the Smart Divorce podcast. I am really happy to be joined today by the very famous Jonathan Galbraith. Now, on this podcast, I don't think I've ever been joined by anybody who has actual tables named after them. So I'm very honoured that he was happy to come and take part today. So for anybody who hasn't heard of Jonathan before, and if you work in the family law world, you absolutely will have done. But if you haven't, he is the CEO of Mathieson Consulting, which are an actuarial firm set up by George Mathieson, very, very, very well known in our world. If you are needing a PODE report, I have no doubt whatsoever that somebody will have suggested that you go to them. He is also the creator of the Galbraith Tables, which I'm sure will come up later on in our conversation. They are intended for using to give an idea, sort of broad brush approach to DB or defined benefit pension rights. He's also the co-author of the Pensions on Divorce Bible, a Practitioner's Handbook, the 4th edition, alongside 3 other eminent authors. We're going to talk today about complex public sector pensions. Don't turn off. This is really important. I know it sounds complicated. We're going to try and help you to understand why you need somebody clever like Jonathan to help you if you have a divorce where any of these types of pensions are involved. So we're going to start off talking about uniformed services. So if you are divorcing somebody who is in the armed forces, in the police, is a firefighter, please, please, please keep listening. If in fact you are divorcing anybody who has a defined benefit pension of any description whatsoever, please, please, please keep listening. And also, just very finally, before I let Jonathan speak and my voice gives up completely, if you have a partner or a spouse you are separating from or divorcing who has a defined benefit pension, please do not listen when they say, do not touch my pensions. Your pensions are part of your marital assets and they need to be considered as part of the divorce settlement. Jonathan is nodding away, which is marvellous. Welcome, Jonathan. Thank you for joining me.
Thank you, Tamsin. Absolute pleasure to be with you today, and thanks very much for inviting me onto your podcast.
I'm delighted and slightly overwhelmed to be in the presence of such a famous person in our world.
Very kind, too kind, in fact.
We're going to talk about uniformed services mainly today, but I have a feeling that we're also going to touch on some aspects of some of the other defined benefit pensions.
Sure.
So it's going to be worth listening to, whatever the situation. So in terms of the schemes that we're generally going to talk about today, can you just give us a bit of an overview and what makes these pensions special?
Certainly, absolutely delighted to do so. Yes, so really thinking here about the Armed Forces pension scheme, the police pension scheme and the firefighters pension scheme. So all defined benefit, public sector pension schemes, anything that comes with a uniform in the job. And what they all have in common is they tend to have preferential early retirement terms compared to the other public sector schemes, for example, the NHS scheme or the civil service scheme or the local government scheme. And these are very much cases, pension on divorce cases where such pensions are involved. These are very much the ones where the report of the Pensions Advisory Group, which of course you and I both sat on, the reformed PAG, the PAG 2 report does indeed suggest that PODE input, the input of a pension and divorce expert, is likely to be required where those pensions exist.
Absolutely. I mean, let's be clear, if there are any defined benefit pension schemes within a divorce, I think PAG would generally suggest that a pensions on divorce expert report would be pretty necessary.
Yes.
And I think when it comes to these uniformed pension schemes, I would say that they're largely quite tricky to understand, and that's why we need an expert like yourself involved at this point. So what are the generous early retirement terms like? What does it mean? I mean, early retirement sounds pretty straightforward to me. They can stop work and take their pension benefits early. And presumably we're meaning earlier than 55, which is the sort of normal earliest.
Exactly, yes. Yes, it's the fact that usually when one seeks to retire early from a pension scheme, you have to take a bit of a haircut to do so. So the pension's payable at 60, you want to retire at 55. If you're not on grounds of ill health, you will suffer a reduction in your pension for going early because it's more expensive to provide a pension from a younger age. But what these uniform services schemes have is generous early retirement terms where if certain service-related criteria are met, you can then retire on pension, on full pension, without it being reduced. I mean, the terms, they differ from scheme to scheme, and it does depend when the individual joined, but the legacy schemes, the older ones, are especially generous. So by that, I mean for joiners before 2005 or 2006, what's known as the Police 1987 scheme, the Firefighters 1992 scheme, and the Armed Forces 1975 scheme. The police and the firefighters schemes, they will allow active members to retire at age 50 as long as they've got 25 years of service, or at any age with 30 years of service. So for example, if you joined the police at 18, you spend 6 months at Hendon, then you actually properly join the police at 18 and a half. You can actually then retire after 30 years of service at age 48 and a half and become a pensioner. And that's quite a bit younger than retiring at 60,
Wow.
65, or at 67.
Wish somebody had told me to join the police. That sounds like a great idea. I could be feet up somewhere by now. That'd be amazing.
Indeed.
So,
But we did.
yeah, absolutely. So that's quite a difference to the minimum age of 55. What does that mean? Because those are some of the older schemes. I mean, you mentioned the Armed Forces 1975, was it?
Yes, that's right.
Crikey, that's an old. Are there different rules for more recent schemes?
Yes, there are. So the previous Labour government did change the schemes round about 2005, 2006. So there's a Police 2006, Firefighters 2006, and Armed Forces 2005 scheme. Those schemes will allow active members to retire at age 55 rather than normal retirement age of 65. And then there are even newer 2015 schemes, which will typically allow active members to retire at age 60, whereas if you are not an active member, you have to wait to state pension age, which might well be 67 or indeed 68 before you can retire. So the early retirement terms still exist, but they're not quite as generous as they used to be.
They've got less good. So you might not want to run off and join the police now if you're 18 for those, but then who knows?
Gotcha. I think that the point there is that they recognise that generally people are not becoming properly pensioners at 48, that most people will be doing something else.
Yeah.
And the argument is, yes, we will give you a generous pension, but if you're going to have another career afterwards, we'll give you the generous pension from a more normal retirement age that is maybe 60 or rather than around about 50.
That sounds pretty reasonable. My painter and decorator used to be a firefighter, so that's probably proof in the pudding, isn't it?
Exactly. There you
go. What about these schemes causes so many problems when we're looking at divorce?
Gotcha. Well, it's a number of things, really. I mean, first thing to say is that any pension that's being shared comes with a cash equivalent value. So this is a valuation of the pension rights that's produced by the scheme. And we PODEs, we pension divorce experts, we need to know that figure to then perform calculations to determine how the pension can be shared with the ex-spouse. And the thing that's interesting about this is the fact that when the member becomes entitled to an immediate pension, that can just, if you like, creep up. So police 1987 member reaches age 50, then all of a sudden that pension is deemed payable now rather than at 65. And this greatly increases the value of the benefits. Would you rather have a £20,000 per annum pension starting now, or one starting at 50, having the same pension starting 10 years earlier. And that is reflected within the cash equivalent value, because it will then jump up overnight, if you like. And the thing that's interesting there about the timing is, if you were to share that pension before the member reaches the entitlement to have it payable immediately, it then means that the ex-spouse is going to get less, and the holder of the pension will then bank all the gains associated with that afterwards. So I really do think that solicitors and people getting divorced really do need to be savvy to this. And I think the other thing to note is that the arithmetic associated with sharing these pensions with the ex-spouse becomes quite a bit more complicated when the member is able to retire immediately but isn't going to. So, for example, someone's in the army, he's got a commission of another 3 or 4 years or something like that. So, barring something happening, he's going to be in the scheme for another 3 or 4 years, but theoretically can take the pension immediately. So when we're writing reports with these pensions, we really do need to understand what is the individual's actual plans for the future. Should we assume immediate retirement? Should we assume state pension age? Or is it 60 or is it 65? And we do need something of a realistic steer there. And I think the other point that's important to note is that these generous early retirement provisions are not extended to the ex-spouse. So the terms very much differ from scheme to scheme, but the old police scheme will insist that the ex-spouse can only retire at 60, or if the member's older than, the ex-spouse is older than 60, then immediately. Can't go early, can't go late. The other ones, the armed forces one, for example, will permit, normally it will assume that the ex-spouse takes the pension at 65 or at state pension age, but will permit early retirement on reduced terms only. So that makes it quite difficult, really. How can we seek to equalise pension incomes in retirement? How is it fair if husband can retire at 52, say, and wife cannot retire to 65?
Yeah, yeah. I recall some toing and froing about this.
Yes.
I'm sure it was called a pension income gap.
Yep.
I feel
Yep.
like it was referred to when we were in PAG, and how that might be, how we might look to equalize that, or how we might look to cover that or bridge that gap. How do, as a PODE, how on earth do you go about dealing with that pension income gap?
Gotcha. Well, we can't always, but certainly we do seek to explain the issue and suggest, excuse me, things that might be done to mitigate this. So when we're writing reports at Mathieson Consulting, we will always draw this to the solicitor's attention, both at instruction stage and also when we're actually writing the report. And what we will tend to do is to place a value on the rights that the scheme member, the husband in the example I just gave, would receive before reaching the common retirement age. So for example, it might be £10,000 a year of pension that he's receiving from 52 to 65, which is the point at which wife can take her pension. And at a very simple level, £10,000 for 13 years is £130,000. What we're going to do is a bit more sophisticated than that. We'll think about tax, we'll think about probability of survival. But in broad terms, we're going to give you a pound note number and say the calculation that we've performed does not allow for this. You will have to think about whether you're going to allow for this somewhere else in the settlement.
Okay.
And I mean, you're quite right. This was covered off in PAG as an income gap. And, there is another way to look at it, which is to say that if we share husband's pension now, he'll suffer an immediate reduction in his pension, but wife won't receive anything for years to come. And so the actual pension benefits payable in the interim period are reduced. Now, there are ways around this. For example, you could seek to settle pensions matters at a later date when wife is able to take the benefits to be awarded to her. But there's a huge number of risks associated with this, and almost all of those are borne by the ex-spouse, by wife in this example. What happens if husband dies in the interim period? She's not then entitled to any pension share at all. She's not entitled to the spouse's benefits, because once the decree absolute, the final order has been given, she's no longer a legal spouse. What happens if husband remarries and then seeks to get divorced again in that interim period? A bit messy, but there is an argument that a second claim could be made over his pension. So it can be done. You can look at ways of deferring this, but it's going to be one party that will suffer more than the other one if this goes wrong.
Wow. I mean, that's a whole lot of risk. So just going back to this, because this is complicated. What you were saying when we started talking about the issues about the cash equivalent value is that the cash equivalent value suddenly gets much more valuable as on entitlement. Could you just give me some? I can't get my head around why that would be.
Sure.
It feels like it would be sensible not to. I'm sure people don't do this, but feels like it would be sensible not to get divorced almost until these pensions are payable.
Sure. It's well to explain that one. Excuse me. It's the fact that the pension is valued by the scheme. Excuse me, based on when it can be taken. So if the member is not entitled to receive the immediate pension, suppose there's an accrued pension of £20,000 a year, and that's payable at age 65, and the member is currently just shy of 50. That is valued as a pension payable at age 65. Okay. And I can't come up with an immediate figure, but let's just say that's worth £250,000. Then all of a sudden,
those Galbraith tables, Jonathan.
Yes, I could look up the table. You put me in the spot now. But if the pension then becomes payable immediately at age 50, the CV might well double, or something not far off doubling. It might then become £450,000, because we're now valuing a pension that's payable immediately from now 50, not 15 years deferred. Now, would it make sense to wait for that point to come? It certainly would for the recipient of the pension. It would be in wife, an example that I gave there. It depends, though. Supposing that point's going to be attained in 10 years' time, I don't think we'd really suggest that a divorcing couple are going to wait 10 years for this entitlement to be received. And again, for whatever reason, the member might leave the scheme before then. It's not guaranteed that the member will stay in the scheme up until the point at which this entitlement is reached. If it's going to happen tomorrow, then I think fairly obviously we allow for it. It's the thing, if this is going to come up in, say, 12 months' time, that's the point at which you think, does it make sense to hold on here, or do we really want to settle matters now? Again, we know what to look out for when we're writing these reports. When these points come up at which benefits suddenly become more valuable, and we will always flag that to say, you do realise, don't you, that in X months' time this pension becomes more valuable. Do you want to proceed now, or do you want to wait? And it's not for us to say what people should do, but we're going to draw it to the attention of the instructing solicitors.
Yeah, no, that makes absolute sense. So I deal with lots of clients who have DB schemes, who have I guess, government pension schemes, public sector pension schemes. I've not very often seen armed forces, police, firefighter schemes randomly. Do these sectors, do they have lots of, like in the NHS scheme, you're likely to be a 1995 member and a 2015 member. Do we have the same situation with these uniformed forces as well?
Yes. Yes, we do. So
just to confuse matters.
Just to confuse matters. So anybody who joined before, I think it's 2005 in armed forces and 2006 in police and firefighters, is in the old schemes. So that's, I think, I said police 87, firefighters 92, armed forces 75, but will then have moved to the new 2015 scheme as at April 2015. There's then sort of the in-betweeners that joined between 2005 or 6 and 2015, who are then in the 2005 or 6 schemes, and then anybody who joined after 2015 is solely in the new 2015 scheme. But then, of course, this was all revisited somewhat because of the MacLeod ruling and subsequent remedy, whereby for affected members who were active in both 2012 and 2015, they will have been rolled back such that their 2015 to 2022 service is then put back into the old scheme, and the member then gets to choose at retirement whether they want the old scheme rules or the new scheme rules to apply. I do realise I've just started shouting a lot of dates at you there, but the names of the schemes.
My brain hurts. Okay, yes. Right. Very slowly for simple people like me who are not actuaries. So if I have my spouse, let's say, has an armed forces scheme, they joined it in time to have the 1975 scheme. They've got some of that, and then they were still active members in 2015 and were chucked into that one as well. But I've got to have 30 years of service in order to take my 1975 bit at, let's say, 50 for nice round numbers. How does that work if I'm also in the other one? Like, does the 30 years stop when I joined the new one, or how does that work?
No, it doesn't. I should just flag for the Armed Forces scheme, they've got slightly different rules. If you
Of
join,
course.
of course they do. If you join the old scheme as an officer member, you could retire after 16 years of service, or if you were non-officer, so what they call other ranks, it's 22 years. So that's
All
slightly
right,
different.
okay.
It's 30.
Right.
But yes, the simple answer is you can count service in the new scheme towards the 16 or the 22 or the 30 years.
Right.
If they hadn't done that, it would have been quite unfair, because it would then mean that anybody who had just missed it when they were moved to the new scheme would never ever be able to retire early. So that's actually based on, if you like, years of employment rather than explicitly the scheme service in the old scheme. So you can count the new scheme service as well.
Okay. Fab. And the new schemes for all of those uniformed services, are they all still final salary? Are they in this career average situation that lots of the other public sector schemes are in?
Yes, they've all moved to career average. So that's true across all of the public sector schemes, including the NHS one. They're all career average. So what career average means, rather than final salary, meant that the pension that you received in retirement was a function of the last salary you received and the number of years of service that you had. Career average revalued earnings, or CARE, is where what we do is we look at what was the salary that I had in every year that I was working, and it's then an average of those salaries, but those are all inflation adjusted. So that will be inflation adjusted to take you from 2025 to 2045, recognizing that the time value of money has changed. And I think it's also useful to know that for the active members of these schemes, they do get some form of enhanced increases. So I think from memory, the police pension scheme, it's not just that the pension gets uplifted every year in line with CPI inflation. There's also a further 1.25% bonus that's given on top for active members. And it should be understood that that might well be more than the rate at which salaries have increased at, particularly when there is or has been any kind of freeze in public sector pay. It may well be that price inflation plus 1.25% is more than your salaries are going up by. So the thing that's always got to be remembered about these new schemes is they are not necessarily a raw deal. Depending on people's circumstances, they might actually give you a better pension than you would have received under the old rules.
Yeah, absolutely. No, that's a fair point. Just want to go back a little bit and pick up on McLeod, because this is another mind-bending
It's horrible.
situation that we all find ourselves in. So let's take it very slowly, one step at a time. So
Yep.
Can you start by telling us, what is McLeod? Why are we talking about it? What is the relevance in divorce situations? There's lots of questions there, sorry.
Yep, no problem at all. So it is a court ruling that affects the public sector pension schemes, and it goes back to what was the Conservative Lib Dem coalition government that came into power back in 2010. They had a go at reforming public sector pensions, and they tried to do something more radical than the previous Labour government had done, in that they wanted to come up with reforms that would affect existing members of the schemes, not just the new members of the schemes that were joining thereafter. And what this involved was they wanted to move to the career average schemes. They wanted to come up with schemes that would pay benefits at state pension age rather than at 60 or 65. They made the accrual rates more generous to compensate for some of the other changes. And these schemes also didn't come with an automatic tax-free cash lump sum. You might be aware that many of these old schemes, it's pension plus 3 times tax-free cash lump sum. They wanted to scrap the automatic lump sums. And I think the legislation was passed in 2012, the reforms came in 2015, and members moved across. But not all members moved across. They did something, this is probably an old-fashioned name for it, but they did something called grandfathering, whereby members who were reasonably close to retirement, within 10 years of normal retirement age, would stay behind in the old schemes. And members who were, I think it was 10 to 13 and a half years away from retirement, would move to the new scheme, but at a date after 2015. And that's the issue there. This was challenged by MacLeod, who is a judge, with reference to the judicial pension scheme. You might have also heard of Sargent, who was a firefighter, and the issue is sometimes called MacLeod and Sargent, although it's two separate cases. And it was challenged on grounds of age discrimination. You have done something different for older people than for younger people. Again, I think sometimes, I'm not a lawyer, sometimes these things can be objectively justified, but I think it was held that His Majesty's Treasury had not properly justified this, and so the whole thing then had to be unwound off the back of having lost the court case. It wasn't as simple just to say, all right, well, we'll just put everybody back the way that it was, because you cannot level pensions down. We talk about leveling up and leveling down. You cannot just say, oh, well, we're just going to reduce your pension then. The way they've had to tackle this is this sort of heads I win the member, tails you lose the taxpayer thing, whereby the member for this remedy period of 2015 to 2022 then ultimately has to be able to have the better of what the old rules would have been or what the new rules would have been. And that's what gives rise to affected members then being rolled back into the old schemes for this 7 years of accrual, but then having the right to have the new scheme rules applied if those give a better outcome than the old scheme rules. And again, for those of us who deal with this, public sector pensions used to be quite straightforward to deal with, but this really has thrown a spanner in the works, and some of this gets a bit messy, not least when there is an entitlement to take benefits at a comparatively young age in the old schemes that is not extended to the new schemes.
Wow. Okay. So the impact for quite a long time of MacLeod for those of us who work in this area was that public sector schemes were having huge problems in actually even getting a cash equivalent value. We seem to be, touch wood, getting through that now, and we seem to be receiving suitable cash equivalent values. Do we still, so for cash equivalent values that are being received now, if I'm advising a client now, I've got a cash equivalent value that's been received in 2025, do I still need to ask the actuary or the PODE to comment on MacLeod and any impact that MacLeod will have?
I think it's perfectly valid to ask that question. I think any good PODE who knows what he's doing should be doing that automatically, but by all means, ask that question. It should be made very clear on the cash equivalent statement that MacLeod has been allowed for. The easiest way that you can check for it is if you have the old scheme, so again, Police 1987, NHS 1995, if it says final date of service is 31st of March 2022, rather than 2015, then that makes clear that they have allowed for MacLeod.
Perfect.
They have back those 7 years of service into the old scheme.
Wow. Okay. So we are getting somewhere with MacLeod, because that's just been an absolute, just a pain in the neck, hasn't it?
It has. I mean, I think the one that's had a particularly bad press of late has been the teachers' pension scheme.
Absolutely.
Yeah, and that's the one that I think has really made the papers. And I think there's a Facebook group out there called I Want My CTV of teachers, again, who are getting divorced. And this is the only thing that's been hanging about, but they can't complete the financial remedies piece because they can't get the CETV. I think what we've seen is that almost all schemes now are largely up to date for non-retired members, so active and deferred members. When the decision on MacLeod doesn't need to be made until retirement, the schemes are coping with that. The issue is for pensioner members who have to make an immediate choice as to, do I want the old rules applied for the 15 to 22 or earlier exit period, or the new rules? Because the fact the member is retired, it is now quite cut and dried. The old scheme rules will give a pension of X, the new scheme rules will give a pension of Y. You've got to choose which one. But the schemes need to tell the members what the options are. and the members then have a year to decide. And it's my understanding that these schemes will not issue cash equivalent transfer values until that decision has been made. So it's possible, if you have McLeod affected retired members, that they might still be struggling to get CETVs, and that might well be the case for a few more months.
Let's hope it's only a few more months, not a few more years.
Right.
Crumbs. Right. Okay. So then we have the additional complication, because we like additional complications.
Of course we do. Of course we do.
Of early departure payments.
Yes.
Sitting. What are they? What do we need to think about?
What is an early departure payment? This is a feature that is unique to the Armed Forces Pension Scheme. It doesn't come up with police, doesn't come up with firefighters, it doesn't come up anywhere else. It's just the Armed Forces Scheme. And what it is, it's a bit like a pension, but it's not properly a pension. So as I said earlier, the new Armed Forces Scheme, the 2015 scheme, will pay benefits at state pension age to members who leave service before age 60. The EDP, the early departure payment, it's an arrangement that pays a lump sum and a temporary pension until state pension age to compensate for that later retirement age. And it's payable for those members who've passed what they call the 2040 point, in that you need to have 20 years of service in the scheme and be aged at least 40. And the issue that you've got here is the EDP benefits are not shareable upon divorce. They're not included in the CEV of the Armed Forces pension benefits. They don't have a CEV of their own. It is questionable whether they are genuinely pension rights that should be even considered in a report, because they're not payable for life. But when they come up, I would always seek to mention them where relevant. And the thing that's really horrible is where you've got this interaction of EDP with the McLeod issue, because it's one of these things that the EDP benefits are also affected by McLeod, because they are calculated as a function of the 2015 scheme benefits. And it may well be that members might want to have the new rules applied to their McLeod service, because it will give them better EDP rights. And again, this will all be set out to the member. The Armed Forces Pension Scheme is sending out statements to members that explains this is what you get under these rules, this is what you get under these rules. But I've seen some of these statements, and they're not necessarily the easiest thing to follow.
That doesn't surprise me. If they're not, so they're not, they might be pensions, sort of.
Yeah.
But we're not sure whether they kind of might not be, because they're a temporary thing, but they are based on a pension scheme.
Yes.
They are impacted by McLeod.
Yes.
They're not shareable.
Yes.
We don't do this anymore, really, but can they have attachment orders attached to them?
It's my understanding that they cannot have attachment orders put on them.
Okay. So it's an offset situation. If we've got
exactly.
Okay.
It falls outside the jurisdiction of the pensions regime as is applied upon divorce, but it's still certainly something that the parties need to know that one party is going to receive and the other party is not going to receive. And there's an argument that it should be allowed for in a report. And again, I said they don't always come up, but when they do, we certainly do. If it cannot be allowed for in the calculations, we will certainly make it clear you do need to understand this member is going to receive this benefit for the following number of years.
Crumbs. Wow. And it could be quite a long time.
Yes. Yes, absolutely. I mean, as I said, this could be payable from age 40 onwards upon leaving service until age 68. So yes, that could be 28 years of temporary pension. And
that could really add up, couldn't it? To
yes.
quite some money. Right. Crikey. So we've mentioned that potentially the way round, or a way round that, if there's capital available, might be to look at offsetting, because it's sort of the only option.
Yeah.
Is offsetting ever appropriate for other parts of uniformed service?
It can be. It definitely can be, but it does depend. That's always the answer to everything. It depends. I think what has to be understood is that these are disproportionately valuable pensions, certainly compared to the salaries that one might receive in these roles. And the other assets may not necessarily exist for offsetting purposes. Take, for example, armed forces, where the couple are in forces accommodation. They might not own any actual property. and you then have a pension that might have a cash equivalent value of £500,000. Where are the assets to offset that? They're probably not going to exist. And if that's the case, then you don't have an offsetting option. The only thing you can do is sharing, because there's literally no other assets. And I think if you're going to go down that road of offsetting, you need to make sure that the pensions are being valued fairly. Something that I'm sure, Tamsin, you and I have both been telling solicitors and people getting divorced over the years is that cash equivalent values of defined benefit pensions are not necessarily reflective of fair value.
No.
It'll tell you it's a big number, but it's not necessarily something that can then be compared with equity in former matrimonial home. So you could use the Galbraith Tables, shameless plug, to value pension rights, or you could ask a PODE pension divorce expert to consider that in more detail. And I think the other point that I've made before is that do remember that the benefits can shoot up in value, in the same way that the CEV can go from 200,000 to 400,000 when immediate payment is reached. Any other value of those rights will also go up. And I think this is often the thing that that family solicitors are particularly wary of. To put it bluntly, being sued for negligence when pensions issues have not been dealt with properly. I think the important case of recent times is Joanne Lewis and Cunnington Solicitors from 2023. Full disclosure, that was a case that I was involved in as an expert witness. It was a negligence case where Mrs. Lewis had been, I think it's fair to say, poorly advised by her solicitor. She just wanted to finalise the divorce from her husband, but had no idea of what she was waving goodbye to. Husband had a legacy police pension with a cash equivalent value of over £500,000. Even if that's not the fair value, even if that's not the right number, I think we're all agreed that the right number is going to be a big figure as well. And she didn't know what she was saying goodbye to. That was the point there, and that was what she won on, really, that she'd not really been properly advised. So I think it always comes back to the point that solicitors do need to know what they're doing with these sorts of pensions, and parties, particularly the spouse, if husband's got the police pension, particularly wife, needs to know, at least in very broad terms, what husband's pensions are worth.
Yeah, absolutely. I think so. I wrote an article some time ago about whether a PODE report is necessary.
Sure.
It's still the most well-read article that I have available on my website, despite having written hundreds of others. Because broadly speaking, people don't, well, they're divided, but don't want to pay.
Yep.
They don't want to pay. Spouse doesn't want to pay for the report. And or one of them has said, we're not going to touch each other's pensions. So generally, when I receive an email saying, I don't know whether we need a PODE report, I think maybe once out of, and I probably get these weekly, maybe once I've said, probably don't.
Yeah.
Because they were both DC schemes, no guarantees, very, very small. And similar, parts of similar ages. So probably not. But the majority of times you need to spend the money. So could you just explain why it's worth spending the money on a PODE report, and why it's essential that both parties pay the money out? Because there's a kind of feeling that, well, hang on, it's my huge pension. Why would I want to pay for my ex to be able to have a share of it?
Yeah, good questions all. I mean, I think we're not lawyers, but I think it is established within family law that pensions should be considered on divorce. Absolutely. In some form, that the individuals don't just get to hang on to them and then we just deal with all the other assets. The pensions ought to be considered. And I think it's the fact that it is easy to get it wrong, particularly, I think as we said, if you've got defined benefit pensions and we're just going to use the CVs and come up with some offsetting solution, it is quite likely going to be unfair to one party or the other. It's perhaps not immediately obvious to whom such a blanket solution would be unfair to. And so I think that's one of the reasons why one gets a PODE report, that it's it's somebody having a fair and objective look at this and saying, well, this is what would be fair, and obviously somebody's going to gain and somebody's going to lose compared to simply using the CVs, but then everybody can then be agreed that it's fair. I think for the solicitors as well, many of them will have perhaps some PI requirement to look into this. I think many solicitors, particularly after the Cunnington's case, do feel quite exposed. They do not explicitly want to opine and say you don't need a report here. If they've got any doubts, they will probably err on the side of caution with getting a report. But I do completely agree with you. If you've got parties who are young, which might be in their 30s or their early 40s, I decided I'm still young, then, and they've only got defined contribution pensions, these pensions are not going to have any guarantees. Guaranteed annuity rates, I think it's fair. If you've taken out any kind of arrangement after, say, 2000, you're definitely not going to have any kind of guarantees. I think it would be overkill to seek to have a PODE report then. But again, it's when you've got private sector defined benefit schemes, when you've got cases where the pension assets are maybe very material compared to the other assets, and in particular where you've got these uniform services schemes where you can have pensions at a young age in payment, but that will not be extended to the ex-spouse. I think these are the ones where it is mission critical to make sure that those issues are properly considered by somebody who's going to have a fair and objective look at it.
Yeah, absolutely agree. I think the majority of the people who are approaching me to ask, do we need this report? I think the majority of them are not supported by solicitors.
Sure.
Or
No,
the solicitor has recommended it and they're not quite sure that that's absolutely essential.
Yeah.
So yeah, it's always worth having the conversation.
Yeah.
Fair play for people checking, but normally the answer is sorry. Yes, it is necessary to spend the money.
Yeah, and I get that. It's a grudge purchase. I would imagine that all costs associated with divorce is a grudge purchase. This is even more of a grudge purchase. But again, I think that people would recognise, though, that pension assets that a couple in the 40s or 50s or in retirement would have might well be the most valuable or the second most valuable assets they have after a house.
Yeah,
and if you're getting divorced, and the house is being sold on divorce, you're going to make sure that gets valued properly. You're not just going to say, oh, well, we bought it in 1987 for £50,000, so we'll just guess what it's worth. No, you're going to look at that properly, particularly if one party is going to stay in the house. And so as a result, why wouldn't you do that with pensions as well?
Yeah, no, absolutely. So you created these tables.
Yes.
And that feels a little bit like you might have been doing yourself out of a job. I'm sure I'm not the first person to suggest that might be the case.
No, not the first one, no.
Can somebody use a solicitor, for example, use your tables, and then their lovely clients not have to bother spending the several £1,000s to get the report that we've just told everybody is essential?
An excellent question. Have I climbed up a tree here then decided to saw off the branch that I'm sitting on?
I mean, a bit.
But no, I think it's fair to say that there are a huge number of divorces where no pensions report is sought. I think there's 100,000 divorces in England and Wales. There are most definitely not 100,000 pension and divorce reports being written. And again, I think it was said,
you'd be very busy, wouldn't you?
Exactly. I would be very busy indeed. I think it's fair to say that in many cases it's quite right that a report isn't sought, but there maybe are cases where solicitors who are comfortable using the tables and read all the caveats that go with the tables are happy to use it. I mean, I think the tables, they're useful for placing a ballpark value on pensions. That's what they're designed to do. They don't get into all the intricacies that might exist, and that's made very, very clear within the tables themselves. But again, could they be used at letter of instruction stage if a PODE is going to be appointed? And it goes back to that question, is it worth asking for offsetting numbers if there are no real assets against which the pensions can be offset? And again, exactly, what's the point in doing the offsetting figures if there's no assets? So I think they can be useful there. And I think, yes, they can be useful in other cases. But in all honesty, I've still got lots to do in terms of writing reports. And since we published the tables, that hasn't dried up the work in this space. I think there's always going to be cases where proper expert witness testimony is going to be sought because the issues are sufficiently complicated. But if at the simpler end of the spectrum, the tables make life easier for family solicitors and indeed people getting divorced, then I would be delighted to think that.
Excellent. Okay, we're coming to the end of our time together, which is probably a good thing because my voice is giving up now. But is there anything that I should have asked you that I haven't? And are there places that people listening can go to for further information?
I think we've thrashed this one out pretty comprehensively. I can't think offhand of anything else that needs to be said in that. Useful resources. I think I made a reference to the PAG report, PAG 2, as it's now on to, which we both sat on that. This is a thing that's seen very much as the standard text that is followed for dealing with pensions matters on divorce. It's been endorsed by two leading judges. And I think it's one of the things it's sought to do is encourage a more uniform practice of how such matters are dealt with in court on divorce. I know that solicitors do refer to this document very much. And then shameless plug is, you mentioned it earlier, Tamsin, Pensions on Divorce, a Practitioner's Handbook, Volume 4, written by myself, His Honour Judge Hess, and barristers Rhys Taylor and Joe Rayner. And this, as I said, is the 4th edition of this book and the first one that I've been involved in. And I have somewhat rewritten what it says on the actuarial chapters, and particularly on those public sector pensions. That's all been rewritten to reflect MacLeod, all the new schemes that have been introduced and so forth. All the issues that we've referred to today are discussed in the book in some detail.
Perfect. And that book, not necessarily one that you want to get your hands on if you're going through divorce yourself. It's quite a tome, but certainly if you're involved in the area of pensions on divorce as a practitioner, as a professional, it should be sat on your desk day in, day out. It's certainly my Bible. In terms of the PAG report, itself, I would say it's fair to say it's relatively readable.
Yes.
Not in lawyer speak, which is good for me because I don't speak lawyer very well. And it is quite readable. However, it is quite long. You might find that it's not particularly been written for the general public, for the divorcing people. However, there is if you go to advice now, I think it's .org.uk, and you will find the pensions on divorce guide, which is a survival guide for pensions on divorce. The yellow guide, sorry, it's not a yellow guide, it's an orange guide. It's fabulous. It's written in very, very much in plain English, but based on the findings of the PAG report. So if you're going through divorce yourself and these wonderful publications that Jonathan's talked about make your head want to explode, please use the survival guide because it's pretty comprehensive in one.
It's very good. Yeah.
So last thing I need to check with you before we disappear is how can people get in touch with you, Jonathan, to instruct you to write their report, or at least Mathieson Consulting?
Certainly, you can find us online at www.mcact, that's mcact.co.uk. As a general rule, we take instruction via solicitors. We would typically expect both parties to be represented by solicitors. We will often consider cases where one party is represented by solicitors and the other party is self-represented, what's known as a litigant person. We would typically take cases when neither party has solicitors, but we do judge cases on their own individual merits.
Perfect. Wonderful. Thank you so much for joining me today. That's been
my pleasure.
Absolutely enlightening. I hope that you listening have found it useful. If you do have any questions or queries, please do get in touch. Hopefully this has laid to rest some of the queries that you might have. And if you have enjoyed today, please do leave us a review. And thank you for joining me, Jonathan.
Thank you very much indeed, Tamsin.